You suffered significant harm and injury as a result of a doctor's carelessness. You went to the best attorney you could find, who then obtained the best medical expert he could find to have your records reviewed. The medical expert confirms that you do in fact have a valid case, that your doctor was careless and that he violated the basic standards of medical care, that as a result of that wrongdoing you suffered horrible injuries, and that your injuries are permanent and significant. And now your attorney goes ahead and prepares the documents necessary to start your lawsuit, which is known as a summons and a complaint. The complaint is a document that itemizes and makes various allegations against the people you are suing. Now, the next step that happens once those documents have been filed in court and your lawsuit has actually been started is now we have to deliver that document to the people you have sued. Whether it's a corporation, whether it's a medical group, whether it's a doctor who treated you, those documents have to actually be served. What happens, though, if we go ahead and make attempts to deliver those documents to the various people you have sued, and let's say the doctor you sued turns around and says, I never got this. I never got any document. I never got a summons and a complaint telling me about this lawsuit. I can't be part of this case since you never told me about it. Now, what happens if that really occurs? I'll tell you what happens. One of two things is going to happen. If we get knowledge that the doctor refuses the paperwork necessary to go ahead and start your lawsuit, then technically we have not yet served him. Now, what does that mean? It means that the court in which your case is pending now does not yet have jurisdiction, does not have the ability to render orders and to control what happens in this case and to the parties in this case, which means the doctor's still not a participant in your lawsuit yet. And the doctor and his attorney may simply do everything possible at that point to simply say, look, you guys never delivered those papers the way you should have. We never received any of them. It was never served on me. It was never served on anybody else. I didn't receive it in any other fashion. I have no idea what you're talking about. This is the first I learn about it. So what's a request for a default? So let me give you an example of what a default is. Let's say you go to a baseball game. You go to the Yankees, you go to the Bronx, and now the Yankees are playing the Mets. The Mets fail to show up. Everybody's sitting around waiting for the game to start. The Mets simply don't show up. Who knows why? Well, guess what? The Yankees will win that game by default. The same exact thing occurs in a lawsuit. If the people whom you have sued fail to show up and answer the allegations, you will win your case by default. Getting money out of them is a different story. But just establishing that they did not answer the allegations means you can now request that the court give you an automatic win as to liability, as to the wrongdoing causing injury. You don't get an automatic win as to how much you're going to get. Instead, there's a separate process after that, where now we have to ask the court for something known as an inquest. And an inquest is a hearing where the court will take testimony from you, the injured patient, as well as any of your treating doctors. And after listening to testimony about the injuries that you have and all of the problems that you have, the judge will then come to a decision as to the value of your injuries. And then the judge not only will establish that the defense, the doctor who is involved in your case, has failed to go ahead and answer the allegations, so you get an automatic win there, but as a result of that, the doctor now becomes responsible for paying the full amount of the damages that the judge determines you are entitled to receive. In that instance, now you have what's called a judgment. And now you have to take that judgment and try and squeeze money out of a stone and try and identify where the doctor may have assets available that you can try and seize and liquidate as a result of this particular judgment. But let's get back to the question I raised at the beginning of this video. What happens if the doctor turns around at the beginning of your case and says, listen, you did not serve me with these papers as you're supposed to? Well, sometimes we can have what's known as a traverse hearing. Now, what's that? It's a hearing to determine how these papers were actually delivered. Now, the person who is tasked with delivering these papers is typically known as a process server. Their entire job is to take legal papers and deliver it to various people who are being sued in these various legal actions. we will have to have the process server testify in court about exactly what he did on the different days to deliver this particular set of papers. And the court will listen, and he will be subject to cross-examination by the doctor's attorney. Now, in order to properly serve someone in a lawsuit, if they are not willing to accept the papers, there are alternative ways in which a process server can actually go ahead and deliver those documents. So the process server may actually find the doctor walking down the street and say, "Hey, Dr. Jones, I have something for you." And he's like, "What is it?" And he's like, "Oh, I have some documents for you." And he's like, "I'm not touching anything." And now he tries to give it to him, and the doctor runs off. Okay, that technically may not be good service. So in that instance, the process server may have no choice but to try and deliver those papers in an alternative means. And oftentimes that's known as nail and mail service, which means mail it to the last known address that we have on file, or that's known commonly for this particular doctor, and then take a copy of that document and actually attach it to his home address and attach it to the door. That's known as nail and mail service. In that instance, now the process server will go ahead and explain to the court that this is how they went ahead and delivered the documents to this particular doctor. Likewise, there is another alternative method, and that is, especially if you're serving a corporation or a medical group, and that's to deliver the documents to the New York Secretary of State. And there are very specific ways in which to do that. So if the doctor disputes ever receiving these documents, well, guess what? Now the process server has to come in, the judge will listen to testimony and cross-examination and explore what his logbook reveals. So now let me share with you something that nobody talks about, and this is critically important, and it could mean the difference between going forward with a valid case or getting your case thrown out. If the doctor claims that he did not ever receive a copy of the complaint, we would simply have our process server reserve the doctor, and now we can go forward once we get good service on the doctor. However, what happens though if our first attempt to serve the doctor was close in time to the time limit in which you had to file your lawsuit? And now we thought we had good service on the doctor. The doctor disputes it, claims he never got anything, and now while this dispute is ongoing, we turn around and say, "You know what? Let's go ahead and try and reserve the doctor." The problem will come up is that if your time limit to file your lawsuit has now lapsed, you are going to have a significant problem if the court agrees with the doctor that he was not timely served, and now you can no longer reserve the doctor. Why? Because your time limit to file your lawsuit has lapsed. In that instance, you are going to be out of luck, and you are not going to be able to proceed forward against this doctor whom you believed was initially properly served. So why do I share this information? I share this because nobody talks about this. Nobody addresses this. I haven't seen any articles about this. I haven't seen any videos about this. It's critically important to understand as you are deciding whether to go forward with a lawsuit, how the legal process works in New York. You know, I recognize you may have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.